For example, it claims that the existence of, I quote, an ethnic cleansing motive does not preclude the existence of genocidal intent, end of quote. However, motive and intent are not the same, a point the Gambia accepts. While motives explain why a person is doing something, intent refers to the person's aim or objective. By an ingenious parlor trick, the Gambia simply declares all other intentions, including the intent to defeat terrorists, to be motives, so that the intent to destroy remains the only reasonable inference. But as the court found in the Bosnia and Croatia cases, ethnic cleansing, discrimination, and punishment fall under intent, not motive. And the same, of course, is true for the intent to defeat terrorists. Even if a pattern of conduct could be underpinned by two or more different intents at the same time, it would still be necessary to prove conclusively that genocidal intent was indeed one of them. On the screen, you can see several possible intentions on the right-hand side, including the intent to destroy, an intent to kill, an intent to cause bodily harm, an intent to punish, an intent to take revenge, an intent to discriminate, or an intent to displace. In order to conclusively prove the existence of the intent to destroy, the intent to destroy must be the only reasonable inference to be drawn from the pattern of conduct. If both an intent to destroy and another intent can reasonably be inferred from the pattern of conduct, then genocidal intent is not the only reasonable inference, and consequently, the standard of proof is not met. Mr. President, the Gambia further argues that Myanmar fails to establish the existence of any other reasonable inferences to be drawn from the alleged pattern of conduct, leaving genocidal intent as the only inference that was reasonable. This argument is based on a misunderstanding of the rules on the burden of proof. Myanmar does not have to prove other reasonable inferences that could be drawn from the alleged pattern of conduct. On the contrary, it is for the Gambia to establish that genocidal intent is the only reasonable inference, something it has not done. It is also not correct that there are no other reasonable intents that could be inferred in the present case. I have just shown you a whole list of other potential intentions. The Gambia itself mentions counter-terrorism as a potential other intention. Counterinsurgency could be another intention, and so could be revenge and punishment. During the oral hearings on provisional measures, reference was also made to other reasonable inferences, such as ethnic cleansing. Myanmar submits that the information in the Gambia's written and oral pleadings provide ample alternative inferences to be drawn from the alleged conduct, other than genocidal intent. Let me conclude. The Gambia has the burden of proof to establish the existence of each and every fact that is required to establish the alleged breaches of the Genocide Convention. It must do so by meeting the heightened standard of fully conclusive evidence, that is, evidence beyond reasonable doubt. Where genocidal intent is to be established by circumstantial evidence, the conclusive evidence standard of proof is only met if genocidal intent is the only reasonable inference to be drawn from the facts in question. I thank the Court for its kind attention. Mr. President, may I ask you now to call on Ms. Cordone to present Myanmar's position on the method of proof. Thank you.
I thank Professor Talmon for his statement. I now invite Ms. Kiara Cordone to address the Court. You have the floor, Madam.
Mr. President, Madam Vice President, distinguished members of the Court, it is a distinct honour to appear here before you. Professor Talmon has addressed the burden and standard of proof, and it is my turn now to address the methods of proof. Let me start with the obvious. Not all evidence is to be given the same weight. Passage of time, hearsay, opinion rather than facts, all affect the weight that is to be given to evidence. The Gambia does not dispute these general principles of the law of evidence, but it disregards them in practice. For example, while it accepts that opinion evidence has no evidential weight, it repeatedly advances such evidence. While it does not dispute that hearsay cannot be conclusive evidence, it consistently relies on hearsay evidence. And while it does not dispute that media articles are not, quote, evidence capable of proving facts, unquote, it extensively references media articles in an attempt to bolster its otherwise weak evidence. These principles are not an end in themselves. Together with the best evidence rule, they ensure that the Court gives due weight only to those pieces of evidence which can safely be afforded such weight. Mr. President, let me move on from the general principles to particular types of evidence. The Gambia relies overwhelmingly on reports of the Independent International Fact-Finding Mission on Myanmar, the FFM, as well as reports of other official bodies and NGOs. According to the Gambia, these whole proceedings are essentially superfluous. The presentation, testing and evaluation of evidence, the hearing and cross-examination of witnesses are all a waste of time, because all the facts, including genocidal acts and genocidal intent, have already been established by the FFM. No need for the Court to go any further. Just adopt the findings of the FFM and these proceedings can conclude today. But the Court, however, cannot avoid its duties and absolve itself of its judicial responsibilities. It is for the Court to test the evidence, establish the facts to the requisite standard of proof, and then come to a verdict. There are no shortcuts here. It is for that reason that Myanmar calls on the Court to carefully assess and weigh the evidence put before it, especially the reports of the FFM, the IIMM, and the reports of other UN bodies and NGOs. Members of the Court, the Gambia tells you that you have relied on such reports before. But for what purpose? The Gambia does not say. Was it to establish a simple fact, such as the date of a meeting? or to establish genocidal acts and intent. Neither in the Bosnia nor the Croatia case did the court rely on such reports for evidence of specific acts of alleged genocide or of genocidal intent. The Gambia also does not tell you what evidentiary weight you attributed to such reports. Were the findings of fact in those reports simply noted, treated as credible, persuasive, or treated as conclusive, because it is conclusive that they must be in the present case. As with other methods of proof, the relevance and probative value of these reports must be considered on a case-by-case basis. The court has identified the key criteria which bear on the relevance and value of such reports. First, the source of the report. That is, whether it emanates from a single source or multiple sources, and whether the source is partisan or neutral. Second, the process by which the report has been generated. For example, whether it's based on anonymous sources or whether it's the product of a careful court or court-like process. Third, the quality or character of the report. That is, whether it contains statements against interest or statements of agreed and uncontested facts. Fourth, the first-hand nature of the report. That is, whether or not the body creating the report had access to the territory in which the events in question occurred.